This is Barry Zalma on insurance. I'm an attorney who has retired from the active practice of law and spend my time now as an insurance claims consultant and insurance claims expert witness, an author and producer of these videos. Today we're going to talk about one of the most important aspects of insurance, and that is the doctrine of Uberrimae Fidei, Latin for the utmost good faith. Ethics is a process of systematically applying, using, defending, and recommending concepts of right and wrong behavior. Ethical behavior is required of both parties to a contract of insurance for the system of insurance to work. If any party to the insurance contract acts unethically, does not fulfill the covenant of Uberrimae Fidei, the ability of insurance to work effectively and profitably will fail. Ethics is the essence of insurance. Since insurance was first created, it has been a business of utmost good faith. As a result, the insured and the insurer are expected to treat each other ethically. Insurance was created for the purpose of spreading risk from individuals to multitudes. Spreading the risk in a fair, ethical, and honorable manner from one person to many is the basis upon which a system of insurance was founded. The insurance contract, since modern insurance was first created, was founded on the concept of Uberrimae Fidei. The Latin phrase is used to express the principle that a contract of insurance must be made in perfect good faith, with neither the insurer nor the insured concealing anything from the other that is material to the risk being insured. In the case of insurance, both the insured and the insurer must observe the most perfect good faith towards each other, so that the insurer understands the risk it is asked to take, and the insured understands the risks accepted by the insurer. Insurers and reinsurers are dependent on the utmost good faith, which may be viewed as a legal rule, but also as a tradition honored by insurers and reinsurers in their ongoing commercial relationships. Uberrimae Fidei has its roots in British jurisprudence. The doctrine has historically been applied to all insurance contracts issued in or to be performed in the United States. The doctrine of utmost good faith was stated by the U.S. Supreme Court dating back to 1828. The doctrine imposes the highest duty on parties to an insurance contract to disclose facts that materially affect the insurer's risk. Several federal cases have applied the duty of Uberrimae Fidei in marine insurance settings, applying the doctrine more strictly than in property, casualty, life, health, or disability insurance. Under marine insurance's interpretation of Uberrimae Fidei, any failure to disclose a material fact not known by the underwriter, that is, or should be within the knowledge of the insured party, is grounds for rescission of the policy, even if the omission or misstatement is the result of the insured's mistake, accident, or forgetfulness. In the marine setting, the insured is required to disclose everything that is material to the insurer, even if the insurer does not ask. Not all federal circuits apply the Uberrimae Fidei doctrine to marine insurance policies, but most do. The doctrine of Uberrimae Fidei, the highest degree of good faith, provides that failure by the insured to disclose conditions affecting the risk of which he is aware makes the contract voidable at the insurer's option. Insurance policies, traditionally contracts Uberrimae Fidei, and a failure by the insured to disclose conditions affecting the risk of which he is aware makes the contract voidable at the insurer's option. Similarly, misrepresentation or concealment of material fact by the insurer allows the insured to declare the contract void at the insured's option. The duty to deal with each other with the utmost of good faith is therefore a mutual duty. The majority of courts faced with the application of Uberrimae Fidei to a marine insurance policy have found that utmost good faith applies. Insurance, as a business, as a useful ability to transfer risk, cannot operate without the equitable and ethical doctrine of Uberrimae Fidei. Under the doctrine, the insured in a maritime insurance contract is required to disclose to the insurer all known circumstances that materially affect the insurer's risk, the default of which renders the insurance contract voidable by the insurer. Under the doctrine of Uberrimae Fidei, the parties to a marine insurance policy must accord each other the highest degree of good faith. This duty of good faith requires the insured to disclose to the insurer all known circumstances that materially affect the risk. Because the insured is in the best position to know of any facts that may be material to the risk, the insured is obligated to disclose those facts to the insurer, regardless of whether the insurer makes a specific inquiry about the facts. The age-old federal marine insurance doctrine governs the argument and provides the controlling federal rule, even in the face of contrary state authority. Uberrimae Fidei reflects an enlightened moral policy based on the presumption that the party procuring insurance is not in possession of any facts material to the risk which he does not disclose. Indeed, it is the duty of the insured to place the underwriter in the same situation as himself. An insured who conceals or misrepresents a material fact commits fraud, which avoids the policy and is a clear breach of the ethical obligation of the insured. Fraud is an obvious breach of the contract and the implied covenant of good faith and fair dealing. It is the ethical obligation of the insured to truthfully and fully advise the insurer of the risks the insured is asking the insurer to take. Failure to do so, even if there was no intent to deceive, is sufficient to allow the insurer to rescind the policy if, in fact, the insurer was deceived. In some instances, the law chokes on the issue of ethics and good faith. It is sometimes difficult for a court to determine which of the two considerations influences the classification of insurance contract. At least the insurance considerations have been referred as Uberrimae Fidei in England and in the United States. The two countries, however, are not in accord as to their interpretation of Uberrimae Fidei. For example, nothing is better established in the law of marine insurance that a mistake or commission material to a marine risk, whether it be willful or accidental, or result from mistake, negligence, or voluntary ignorance, avoids the policy. Concealment in the law of marine insurance is the failure to disclose any material fact or circumstance in relation to the subject matter of the contract which may increase the liability to loss or affect the risk or obligation assumed, and which is in fact or law within or ought to be within the knowledge of one party, and of which the other party has no actual or presumptive knowledge. In the case of marine insurance, the insured must disclose all facts material to the risk. In the leading English case of Carter versus Beam, decided in 1766 by Lord Mansfield in the House of Lords, it declared that even an innocent concealment of a material fact made the contract voidable, saying the question must always be whether there was, under all the circumstances at the time the policy was underwritten, a fair representation, or a concealment fraudulent if designed, or though not designed, varying materially to the object of the policy, and changing the risk understood to be run. Now, in Carter versus Beam, the court, as written by Lord Mansfield, found that the insurer was not deceived and therefore was not entitled to void the contract. The doctrine of Uberrimae Fidei obligates the insured to volunteer information which might have a bearing on the scope of the risk assumed, and the failure to do so will allow the insurer to avoid the policy, because the insurer must rely upon the information provided to it by the insured to determine whether or not it desires to take on the risk offered. If the information provided is false, then the insurer has not had the opportunity to make an intelligent decision with regard to the risk. This video was adapted from my book, Ethics for the Insurance Professional, 2nd edition, which is available as both a Kindle book and as a paperback from Amazon.com, and from my website, Zalma.com, by clicking on the link to the Insurance Claims Library, where you will find this book and many others that I have written with regard to insurance claims and insurance coverage. If you found this video to be useful to you or of interest to your colleagues, please refer it to them. It's free. And if you wish to learn about more, please subscribe to the YouTube channel and to my blog so that you can be informed of additional videos and blog postings that I try to make on a daily basis. Thank you.